Good morning and good afternoon, everyone. I'm Fred Buret, Blockchain Investigation Manager at Recoveris, and welcome to another session of digital asset recovery around the world. In this series, we go jurisdiction by jurisdiction, speaking with practitioners who are dealing firsthand with crypto disputes, investigation, and recovery matters. The aim is straightforward: understand the local landscape, the type of cases arising, and how recovery works in practice in this jurisdiction. Today's format is simple, around 30 minutes of discussion followed by a Q&A. So please do drop your question in the chat as we go. We'll respond to them at the end of the webinar. And just a quick note, nothing discussed today constitutes legal or financial advice. This session takes us to Singapore, one of the world's key hubs for digital asset businesses and increasingly an important forum for crypto-related disputes. I'm delighted to be joined by Wern Jhien Yam of Setia Law. Welcome. I'll hand over to you to introduce yourself and tell us a bit more about your practice.
Thank you, Frederick. My name is Wern Jhien. I'm a Singapore-based lawyer, and I am with a law firm, Setia Law. Setia Law is a boutique law firm in Singapore which specializes in disputes work. And in more recent years, we have been doing a great deal of crypto or blockchain-related cases. Speaking for myself, my own practice in the last 10 to 15 years has been focused on asset recovery. And it was a natural, pathway which led me eventually to the work that involved recovery of digital assets in cryptos. So I've had a fair few number of years learning and getting involved, and eventually specializing in this type of work.
Brilliant. So the way we format it usually is that we start about talking a bit more about what's happening in the general crypto sector in Singapore. And so I would be very interested to know what you see, what type of businesses are setting up, and then we'll drive slowly into the disputes that arise from this activity. And yeah, over to you.
No problem. So Singapore has positioned itself as a serious hub for digital asset businesses. So you can find exchanges, foundations, a variety of DeFi projects, and a number of custodians hub and based out of Singapore. We do regulate the digital assets. Our regulator, the Monetary Authority of Singapore, or more commonly known as MAS, have the power to issue DPT licenses. And one needs to have a DPT license to be able to engage in any business that involves dealing with tokens or cryptocurrencies. So there is a sizable and very healthy community of digital asset businesses based out of Singapore, in line with its position as well as a financial hub. But what has been interesting over the recent number of years is that, number one, a lot of the mainstream FIs or financial institutions have also gone into this business. So, for example, one of the largest bank has also set up a digital asset exchange itself, and the exchange is one of the few licensed exchange that operates out of Singapore. So in addition to that, Singapore is also a wealth management hub, in that a lot of the private wealth finds itself hubbed or managed out of Singapore. So we have a number of different type of structures, from your private banking type of structures to family offices. And I mentioned that because in the recent number of years, a lot of these portfolios have seen an increasing a proportion that's allocated towards the digital assets or digital asset projects as an asset class.
Brilliant. And so it's mostly, you would say, individuals, high net worth individuals, adding it, or asset managers adding it to their portfolio, which attracts service providers of all kinds, custodians, exchanges, and over to Singapore. And
exactly. Of course, there's also a growing push to adopt cryptocurrencies as a mainstream form of legal tender for purposes of cross-border payments. And there are a number of licensed companies that provide these services, and it makes sense, especially in a specific region in which Singapore is located, which is Southeast Asia. this is a region that comprises many different type of economies, countries with different laws. So cross-border payments typically are challenging, and crypto has been positioned to solve those challenges, and it's been gaining a lot of traction.
Yeah, and for some years now, it's not. It's something that Singapore has been one of the precursor, in my understanding.
Yeah.
And as a result, do you see? I guess do you see a lot of fraud cases where funds have been sent to exchanges based in Singapore, for example, or the victims or the fraudsters have some kind of link to using Singapore as a the victims would be based in Singapore, or the fraudsters would use Singapore as a way to legitimize their activities while they are running their scams. Is it, and then potentially also more disputes. What kind of cases do you see?
Oh yeah. So I think in short, there has been an explosion in crypto-related cases. So perhaps I can break it down into 4 different type of classes.
Okay.
So the first type of cases that we typically see are what I call the pre-litigation advice. So, for example, in response to hacks or thefts or any kind of security breach, then we will typically be called upon to render advice in terms of recovery strategies. So this is, I think, relates to something you mentioned earlier. The second class of work will be the actual recovery work itself. So, for example, if we have established, of course, working in tandem with teams like yours, Fred, that there is a viable, economically and legally viable path towards recovery, then it comes the time to commence proceedings. And this is where I think the Singapore courts have done a really good job. They have, as a common law jurisdiction, our laws are developed incrementally through case law. And over the last few years, the Singapore courts have been quite active in developing the law on digital assets. So it is now effectively recognized as a species of property, which means we can now get injunctions, disclosure orders, tracing orders, and so forth, all of which are very important tools to aid recovery work. And then the Singapore court judgments can be recognized overseas depending on the specific jurisdictions involved. The third type of cases that we are increasingly seeing recently are what I call your classic commercial disputes, but arising from the crypto space. So anything from your shareholder or founder disputes to governance issues type of disputes or simple contract claims. But they tend to be quite interesting because the subject of the contracts are tokens, and valuation become a particularly challenging issue. And finally, we have also seen a number of very high-profile insolvency or restructuring cases that's out of Singapore. And again, ostensibly, it is not too different from a traditional insolvency case, but when it comes to the issue of valuation, that can become particularly challenging.
Yeah. Okay. On the commercial type of disputes, I actually worked on a case where I use case law from Singapore to justify the data that we're using for the valuation, how we sourced it, but also the methodology behind. And I think more recently there's been another case where there was an average used because the value of the token would be so volatile that the judge decided that there was no one method that would be fair. So you would need to value the token at the time of where the incident happened or the discussion, the conversation started, and then at current valuation as well, and somewhere several times in the middle, so that nobody can pull the carpet towards themselves. So, but yeah, I think valuation is going to be an issue because there's situations where it makes sense to value more at the time of the loss, and there's other situations where a distribution in specie may be possible, and therefore you may not know that's possible in Singapore. Or is it especially if we put insolvency cases into it, is it a court open-minded to the situation, or is it one process and apply?
Yes. So that's actually a very interesting point, because you're right that valuation is typically quite challenging. So when we pursue cases, we typically do have the option of either suing for the actual tokens or the monetary equivalent. And the argument for pursuing the recovery of tokens is usually to avoid the hassle and challenge of having to go through the valuation exercise. But of course, in other cases, most cases actually, tokens are lost, so we have to talk about dollars and cents. And so you mentioned one of the challenge, which is the time of valuation. Another challenge that typically arises is there even a market from which we can benchmark the price? So it's not like, for example, what we can look at a regulated stock exchange in Singapore, for example, to source the price of a particular stock or counter. In the world of cryptocurrency or tokens, that becomes a little bit difficult to explain to a court of law. So that's one key challenge. And thankfully, the Singapore judges tend to be pretty open-minded in terms of the evidence that they want to look at. Another difficulty with token valuation has to do with uh, the non-cryptocurrency type of tokens, for example, governance tokens, utility tokens. How do you derive value? Um, Past transaction, or do you look at the potential rights that the token holder gets from and especially projecting ahead, assuming the particular project grows and turns successful. So these are all challenges that we have seen arising from the cases that we deal with. But thankfully, most of the cases, because it gets so challenging, it creates the perfect incentive for parties to come and talk settlement.
Okay. And that's, I think the fact that you said that judge are getting more familiar with the technology, and also that it's implemented in the regulation that crypto is property. I think it opens doors to this kind of litigations as well, because there's the aspect of cost and risk if the court is not following the case. And so just to get a bit more on the context of these disputes, without sharing too many details, of course, but just to get an idea, what type of disputes is it? Is it traders with exchange, or is it between exchangers, or is it between parties having dealings in crypto? Is it the resulting of a hack where there's less asset in the pot, and then there are disputes around how this needs to be distributed? Is it all of this?
The short answer is it is all of the above. But maybe I can share a few recent cases that I've dealt with without disclosing the confidential details, of course. So a recent interesting case has to do with an ICO dispute. So contracts were entered into at the point of ICO, where they were the company or the project was effectively doing fundraising through the issuance of tokens. And as the project grew, became successful, then there arose disagreement as to whether or not the company or the issuer had the obligation to honor the token issuing obligations. And assuming there's a breach, how do you value the loss that was suffered by the recipient entity? So we have seen 2 or 3 of that kind of disputes in recent times, and those are particularly interesting because many of these entities at the point of ICO, they tend to enter into very brief documentation. That means documents that they may have likely prepared by themselves, because at that time legal fees may be a challenge. So those documents, while everybody was happy to sign on to them when the project is launched and everyone is happy, will become a source of huge contentions or huge disputes when the stakes become higher and higher. So that's one example which I had described as a typical commercial dispute, because at the heart of it was a contractual dispute, but the subject happens to be crypto. Then on the other end of the spectrum are your classic fraud and hack cases. And those are also very challenging because first of all, we need to act very quickly. So when instructions come, it's typically within 48 hours of a security incident, and then we have to work with folks like yours and put together a claim within another 24 to 48 hours. And then you have to trace and you need to decide on a strategy very quickly. So we have we have done maybe a couple of them just in the second half of last year as well, to varying degree of success. I must qualify. But as I said, I just want to emphasize again, thankfully, the Singapore courts, they tend to be very accommodating in terms of giving us an urgent hearing date and giving full consideration to the evidence that we tender.
Yeah. It's good that it gives a good segue into when we speak about the recovery. What are the different tools that enables you to gather information and then freeze the asset and then recover the assets from wherever wherever you successfully obtain a freeze? Is it close to common law, or is it specific to Singapore? What are the different aspects to it, and how does it differentiate to
Yes.
common law, for example?
So we are a common law jurisdiction. So from the time at which the courts recognized digital assets as a species of property, that be resulted in us having access to the full gambit of tools that we have available under common law. So anything ranging from pre-action discovery to tracing, to Mareva injunctions, to receivership orders, to post-enforcement tools. Where Singapore is unique, I would say, is that the rules that govern our judgment enforcement process makes specific reference to the recovery of cryptocurrencies. So it defines property that could be recovered when one enforces a judgment to include cryptocurrencies. And the measures that we can adopt or tools that we can invoke to enforce a judgment is quite flexible. So we have successfully recovered, for example, on a Singapore High Court judgment against an exchange, successfully recovered Bitcoins and other form of tokens, which we then converted into fiat with the court's permission. So, say for that one difference, essentially the tools that we have here mirror what one would typically find in a developed common law jurisdiction.
Yeah, yeah. And can you apply worldwide freezing orders, or because on these cases you don't know what you're gonna find as part of the investigation, and you may want to take the big gears out and try to access any type of assets related to the fraudsters, more than just the ones the assets that you're tracing. Is it something that is available as well in Singapore?
Yes. So I'm about to give my trade secrets away, but I think in principle there are three things that one would typically, three things that we would typically recommend the client consider. One is what you said, worldwide freezing injunction, and the arguments for that, simply put, is that it's a cryptocurrency is a very unique type of property. It could exist everywhere and anywhere. So a domestic freezing injunction most of the time will not be adequate. The second thing we will typically go for is what we call a receivership order. That means we will ask the court to appoint an independent party with the power to collect and manage the assets. And the reason why we typically ask for this is because digital assets, once this can be easily dissipated, and if it's held in private wallets, we are at the mercy of the defendants or the named defendant as to whether or not they want to comply. And in a world where they can be anonymous, there's not much incentive for them to comply. So we typically then ask for a receiver to be appointed with large powers, broad powers, in the hope that they can then be more flexible in writing to exchanges and in working with custodians and so forth to preserve the assets. The third one is basically, and this is unique to stable coins, basically. Is for example, USDT or USDC. The strategy typically will be to engage with the issuer directly and see whether there's there's a way for them to be persuaded to burn, or depending on what blockchain it is, to to put some kind of temporary hold onto the tokens, pending securing a court order.
Yeah, yeah. Exchanges and token issuers, I think, are the key stakeholders to get a recovery from. And yeah, I'm usually asked when I talk to practitioners, is are exchanges compliant with the rest of the with a court order from the UK? Because these exchanges are not usually based in the UK at all. They are based, but they could be serving the UK public. And but one thing is that law enforcement, they are used to receive law enforcement requests or subpoena, but more and more court orders. And for me, back in 2021, when I started, there was a lot of explanation to them that it is equivalent and they should treat it seriously. And I'm not even mentioning when we were coming with an insolvency appointment, because then you need to explain the rule and what you are entitled, information that you are entitled of on the bankrupt or the company. But yeah, is it from the point of view of Singapore? Are you seeing? I know there are a few exchanges based there or having operations from there, but are you seeing some collaboration on this type of cases where you're running after the funds and trying to recover the funds? Are they collaborating with your orders issued by courts from Singapore?
Yes. So even though I'm a lawyer, or we are a law firm, we are realistic enough to know that sometimes it's relationships with these exchanges than to bandish out a court order and threaten them into compliance. So to answer your question, it depends on which exchange we're dealing with. The big ones, they typically do respect and comply with Singapore court orders, even though they are in a far-flung jurisdiction, technically speaking. For some of the others, I think we do have good relationships with people on the inside, and without revealing too much of what exactly we do, sometimes making a few phone calls here and there do help to get them to cooperate. But beyond these two, it's really hard to state with certainty how any particular exchange will react. And even if we are dealing with the same exchange on different matters, sometimes they do respond uh, inconsistently or differently. I'm not sure why, but that's just how it is.
Yeah, change of jurisdictions, for example, or not naming any exchange here, but I'm sure you'll guess. But the and also the type of inquiries. I a lot of exchanges for us are asking for law enforcement involvement, even though we have a court order. And from the UK has been challenging at the moment. I'm sure it will change, but yeah, do you see collaboration with law enforcement is possible when your client, for example, is based in Singapore and there's not much fingerprints from the fraudsters, so you're really depending on your own jurisdiction and yeah, can the police be collaborative from your jurisdiction?
Yes, they can. However, I think the challenge we face is one of geographical limitation. So the Singapore law enforcement, as good as they are they are less inclined to act if the crime is committed overseas or the proceeds are overseas, and they are less inclined to flex their muscle, if I could put it that, and exercise jurisdiction over foreign-based parties. So it's a matter of persuading them to do so, and they have, I must say, they would have legitimate grounds not to if it involves a crime overseas. And Singapore being a small jurisdiction, that is a big limitation in most cases. Unlike, for example, a big country like the US or the EU.
It's just also the numbers of people working on cases and trying to prioritize what they should be working on today. And yeah, very interesting. I'm thinking we can go to the future trends part where I ask where what do you think is what do you think should be done to enable? We're speaking about exchanges fragmented in the world, but and then there are people dreaming about and part of these people are dreaming of some kind of worldwide framework to enable these businesses operating in globally to deleverage their risk and enable like canalize some kind of a collaboration or at least a framework that will enable them to disclose information and freeze funds based on credible evidence that is provided to them. Because today it's a bit on a one-to-one basis. Is it something that you're thinking of applying to digital asset recovery, but also in asset recovery in general? Um,
Yes, so I'm a strong believer in regulatory-driven growth and changes, and that's also partly that a huge part of it is because I'm from Singapore, where the regulators here are really efficient and are always driving changes, even in the economy. So an important lesson that we have learned in Singapore over the last recent years relating to crypto is this problem with scams. And a lot of mom and pop shops and housewives, students, and you name it, has fallen victim to scams, which has exploded because of the ease of using cryptocurrencies as a medium of exchange. And I think that experience has taught us here in Singapore the importance of working across borders, especially between law enforcement agencies and the governments. And thanks to and a large part due to that experience, I have now come to believe that there is absolutely a need to push towards having a harmonized set of laws that would enable or that will facilitate cross-border asset recovery, tracing, investigations, and so forth. But that is more aspirational than realistic because even the question of whether crypto is legal, every country has different answers for that. So I'm not sure whether we will ever get there, but it is certainly something I hope for
it,
almost every.
it may go over the sovereignty of each of this country to decide how they want to deal with it locally, but there could be a kind of subscription model where a country may enable it or not, and then exchanges are or services in general are or financial services in general will opt to be in this jurisdiction because they are in subscribe to this type of and it makes it more credible and attracts more customers because you feel you're protected in case something happen. There will be possibility to and I'm sure the fraudsters will choose exchanges that are not in in under this framework, but I've not heard about anything like this, but I think that there's a growing need for at least some kind of a framework to help. But yeah, but looking at the crystal ball yourself, is there any like the cases you mentioned? There's more and more disputes. Is it a trend that you see growing, or like how do you see the type of cases? What is the
Yeah.
trend?
So at least from the Singapore perspective, we are quite confident that there will be more and more cases involving, and it's for the same two reasons I mentioned at the start. Number one, the involvement of mainstream financial institutions, which meant that huge amount of money has poured into this industry. And with that usually means growth, and at some point there'll be disputes arising from the contracts, shareholders disputes, and so forth. And the other reason why we do believe there will be growth is because, again, a large part of the wealth management structures in Singapore are allocating a sizable portion of their investment or portfolio into digital assets. So there are issues like hacks or fraud, investment scams, and will probably continue to plague this part of our economy, which will result in increasing number of cases.
Brilliant. I think we're reaching the end of our time. If anyone wants to has a question or a topic that we have not discussed on digital asset recovery, of course, please feel free to pop it in the chat at the bottom of your screen. But otherwise, I think we'll wrap up. Except if you want to say anything else, Wern Jhien?
No, just, other than to thank you again for having me this session.
Thank you very much for joining. So a big thank you for sharing some of your insight locally. We live in a world where there's especially in crypto, where different type of cases are happening on each corner of the world, and it's difficult when you're tunneled into your own jurisdiction to see what's happening. We work sometimes on cases in Singapore, so I hope we can work together very soon too. Thank you also to everyone who joined today. Please keep an eye on the Recoveris LinkedIn page for the next episodes. I think our next session is on the 29th of April. We will be talking with a lawyer based in Ukraine. So yeah, I'm really excited to unpack how digital asset recovery works across further jurisdiction. And thank you again for tuning in, and we'll see you very soon. Bye-bye.